What does it mean when three nations at the crossroads of Africa's most turbulent region jointly turn their backs on the world's highest court for crimes against humanity? In the shifting sands of the Sahel, where borders are porous and conflict is part of daily reality, Burkina Faso, Mali, and Niger have made a decision that sends ripples far beyond their own borders. Their coordinated withdrawal from the International Criminal Court, once a beacon of global justice, now raises urgent questions about sovereignty, justice, and the evolving balance of international power. To understand the stakes, picture the Sahel, a region where the landscape itself seems to resist stability. Temperatures soar, the desert steadily encroaches, and resources are stretched thin. Families here navigate a daily struggle for survival, caught between armed groups, military authorities, and their relentless impacts of climate change. In this environment, the decision by these three countries to exit the ICC is not just a legal maneuver, it is a statement, a challenge, and a signal to the world that the rules of engagement are changing. The ICC was established in 2002 through the Rome Statute, a document shaped in part by African voices seeking redress for the continent's history of mass atrocities. Early on, African states were among the court's most enthusiastic supporters. Yet, as a 2023 Human Rights Watch report notes, 9 out of the ICC's first 10 investigations centered on Africa, and nearly all convictions have involved African nationals. This pattern has fueled perceptions, supported by findings from the African Union's 2024 legal review, that the ICC has disproportionately scrutinized Africa, even as it has expanded its reach to cases in Georgia, Afghanistan, and Palestine. This focus has not gone unnoticed. Leaders across Africa began to question the court's impartiality, especially after the arrest warrant for Sudan's Omar al-Bashir. Critics argued that the ICC's actions often seemed to target African leaders, while alleged crimes elsewhere received less attention. The African Union, once a key ally, has debated collective withdrawal strategies and accused the ICC of selective justice. A 2024 AU resolution underscores growing concern over the court's perceived bias and its implications for African sovereignty, with some member states calling for a more unified continental response. Against this backdrop, the recent withdrawal of Burkina Faso, Mali, and Niger must be seen as both a symptom and a catalyst. In their joint statement, the governments, each led by a military junta, accused the ICC of neo-colonialist repression, claiming the court had become incapable of prosecuting war crimes and crimes against humanity in a fair and balanced way. Their exit, coordinated through the Alliance of Sahel States, AES, is framed as a defense against external interference, especially as they confront existential threats from terrorism, insurgency, and economic crisis. To clarify the timeline, in 2012, Mali requested the ICC's involvement, resulting in an investigation into war crimes during the northern conflict and the landmark conviction of Ahmed al-Faqi al-Mahdi for the destruction of cultural heritage in Timbuktu. In Burkina Faso and Niger, the ICC conducted preliminary examinations into alleged crimes during periods of political upheaval, but did not launch full investigations. These interventions were met with mixed reactions, welcomed by some as a check on impunity, but viewed by others as external overreach, particularly as political instability deepened. Recent data from the Global Terrorism Index highlights that Burkina Faso, Mali, and Niger are among the world's most affected by terrorism, with violence and instability disrupting daily life. Political upheaval has become the norm, with military takeovers undermining constitutional order and weakening regional cooperation. Their withdrawal from the ICC follows their exit from ECOWAS, the West African Economic Bloc, further isolating them from established regional frameworks. In response, they have formed the AES to coordinate anti-terrorism, political, and economic strategies. The internal dynamics of these countries are complex and rapidly shifting. Each is governed by a military junta that seized power in the name of restoring security and order amid escalating violence. Yet reports from regional analysts and local civil society organizations indicate that these regimes face significant legitimacy challenges. Public trust in state institutions is low, and many citizens express frustration over persistent insecurity and lack of economic opportunity. A local journalist in Bamako recently shared, People want safety and justice, but they also want to feel that their voices matter in decisions that shape their future. This tension between the promise of stability and the reality of exclusion is a defining feature of the current political landscape. Here, it's worth pausing to reflect. How do you think international justice should be balanced with national sovereignty, especially in regions facing such acute crises? Share your perspective as we continue to explore the layers of this story. The timing of this withdrawal is significant. The Sahel's fragile institutions are under immense strain, and the legitimacy of military regimes is often questioned both domestically and internationally. By rejecting the ICC, these governments are sending a message, not only to their own populations, but to the wider international community. The subtext is clear. Judgment by external institutions, especially those perceived as instruments of Western power, will no longer be accepted without challenge. This stance resonates beyond Africa. The accusation of bias is not unique to the Sahel. Globally, debates about the fairness and reach of international justice are intensifying. While the ICC has expanded its docket, the early and sustained focus on Africa has left a lasting mark. As legal scholars and recent policy reviews point out, nearly all individuals convicted by the ICC have been African men, fueling claims of racial and regional bias. Some see the court as an essential check on impunity. Others view it as a tool wielded by the powerful against the weak. For victims of atrocity crimes in the Sahel, the implications are profound. With the ICC's departure, avenues for international justice narrow. National courts and regional tribunals remain, but their capacity is often constrained by conflict, limited resources, and political interference. Human Rights Watch and Amnesty International warn that this retreat from international accountability could leave victims without effective recourse, eroding protections at a time when they are most needed. The risk, as noted in recent UN Security Council briefings, is that impunity will flourish and cycles of violence will deepen. One underreported angle is the impact on local civil society organizations. Many of these groups have relied on the ICC's presence to amplify calls for justice and to pressure national authorities for reform. With the court's withdrawal, some activists fear losing a vital platform for advocacy. Others, however, see an opportunity to push for homegrown judicial reforms, though they acknowledge that without international backing, progress may be slow and uneven. The impact extends to the global stage. The ICC's legitimacy is built on the participation of its member states. Each withdrawal chips away at its authority, raising questions about its future. The African Union's support for a collective withdrawal strategy signals a broader disillusionment, though internal debates remain. Some member states continue to cooperate with the ICC, emphasizing the principle of complementarity, where the court intervenes only when national systems are unwilling or unable to act. Yet the perception of double standards persists, and the precedent set by the Sahel withdrawals has prompted renewed discussions within the AU about Africa's relationship with international justice. To clarify the complexity of this moment, consider the analogy of a referee in a high-stakes match. When players believe the referee is biased, the legitimacy of the entire game is called into question. In the same way, if international courts are seen as partial, their authority, and the rules themselves, begin to unravel. Comparisons to other regions are instructive. South Africa previously signaled its intent to withdraw from the ICC, citing similar concerns over bias and sovereignty, but ultimately reversed course after intense domestic and international debate. Outside Africa, the Philippines withdrew from the ICC in 2019, reflecting a broader trend of questioning the authority and reach of international institutions. However, there is little evidence of a domino effect in Africa following the Sahel withdrawals, though the precedent is closely watched by both regional and global actors. The geopolitical consequences are far-reaching. As Sahel states distance themselves from international institutions, they risk further isolation at a time when cooperation is crucial. The region's security challenges, terrorism, trafficking, climate-induced displacement, do not respect borders. Weakening international oversight could embolden military regimes, complicate humanitarian responses, and make it harder to hold perpetrators accountable. At the same time, the broader international context is shifting, with major powers like the United States expressing ambivalence toward the ICC, sometimes even threatening sanctions against the court. As we trace the arc of this story, it becomes clear that the decision by Burkina Faso, Mali, and Niger is not just about the ICC. It is about the struggle for agency in a world where power is unevenly distributed. It is about the tension between global justice and national sovereignty. And it is about the search for solutions in a region beset by crisis, where the old rules no longer seem to apply. The Sahel's landscape is marked by more than conflict. It is shaped by centuries of adaptation, resilience, and negotiation. The current moment is a test, not just for the countries involved, but for the international system as a whole. Will the withdrawal from the ICC inspire others to follow suit, or will it prompt a reimagining of international justice? The African Union's evolving stance, combined with growing skepticism in other regions, suggests that the future of international law is anything but settled. Looking ahead, the long-term impact of the AES countries' actions will depend on how they balance the demands of security, justice, and legitimacy. If they succeed in building robust national and regional systems of accountability, their exit from the ICC may be seen as a step towards self-determination. If not, the risk is that impunity will flourish and the cycle of violence will deepen. The story of Burkina Faso, Mali, and Niger's withdrawal from the ICC is, in many ways, a microcosm of larger forces at play. It reflects the enduring challenges of post-colonial governance, the pressures of globalization, and the realities of a world in flux. As international law faces new tests, the choices made in the Sahel will echo far beyond its borders. So as the world watches, the question lingers. In the contest between sovereignty and accountability, which path leads to a more just future for Africa and for us all? What do you see as the strongest force shaping Africa's future? Sovereignty, accountability, or something else? Share your view below.